Good afternoon, everyone. My name is Leslie Dock, and I'm the chair of Protect Our Care. Thanks for joining us. We're here to talk about last Friday's decision that puts at risk safe and legal abortions for millions of American women, and also busts open the door for politically motivated and ideologically driven judges and lawsuits to remove other safe and effective drugs from the market, throwing the entire U.S. drug approval process into chaos. Every researcher and manufacturer out there should be worried about the implications of this lawsuit and the decision. Every patient should be worried. No current drug is without risk, and this ruling allows one judge with a mission to overturn FDA's benefit risk determination going forward. This is the first time since the FDA was established that this has occurred, and unfortunately, it is unlikely to be the last if this decision stays in effect. Confidence that the FDA can do its work is essential for clinicians and patients who depend on it in its decision-making for matters of life and death. Trust in science-based decisions is necessary for pharmaceutical companies to invest in the development of new drugs. And patients, of course, will soon see and could see many more important drugs simply taken off the market. To discuss the impacts of this decision on FDA, on drug approvals, on the drug companies and development, and on patients, we're joined by Andy Pincus, visiting lecturer in law at Yale Law School, and a well-known and well-recognized Supreme Court and appellate lawyer, by William Schultz, former Deputy Commissioner of the FDA and former General Counsel of the Department of Health and Human Services, and by Lynn Goldman, MD, MS, MPH, the Professor and Dean of the Milken Institute School of Public Health at George Washington University. Allow me now to turn it over to Andy. We will be taking questions from all of you listening, as many as we can fit in after the presentations are concluded. Andy?
Thanks, Leslie. It's good to be with everyone. Just want to make clear I'm speaking for myself, not for my employer or any clients. And I thought I would start by setting the stage. Where are we and what's going to happen next? As people probably know, just a little while ago, the Department of Justice applied to the Fifth Circuit Court of Appeals to seek a stay of the district court's order until the appeal process ends. DOJ also asked for an extension of the administrative stay that the district court entered, which I'm sure people know expires next Friday. So that there's time, first of all, for the Fifth Circuit to consider its decision, and then if it decides against a stay pending appeal, to allow for the government to seek a stay pending appeal from the Supreme Court. So I think the next step likely is that the Fifth Circuit will ask the plaintiffs to respond by a specific date. After it decides, if it grants the stay pending appeal, the plaintiffs would have an opportunity to ask the Supreme Court to put the district court decision into immediate effect. If the Fifth Circuit denies the stay pending appeal, then DOJ can ask the Supreme Court for that relief. And DOJ is arguing both that the decision is wrong on the merits, but also that a stay is warranted based on the equities. And just to start with the equities, what courts are supposed to do at this point is to balance the irreparable injury that the plaintiffs claim versus the harm to others that would occur if a stay is not entered, and the public interest. And here, where the drug has been in use for decades, the harm to tens, if not hundreds of thousands of women from removing the availability of that drug would be very, very significant. And the public interest here displacing the expert judgments of the FDA for decades about the safety of the drug. So a very strong case, I think, for the government on the equities to say that a stay pending appeal is warranted. Turning to the district court's decision, the government has a lot of arguments. I'm just going to talk about some procedural ones because you have other people on the call who are experts on the substantive FDA issues. But the first step in any case is, do the plaintiffs have standing? Do they have the real world injury stemming from the defendant's actions that's necessary to allow a federal court to decide a case? And there's a very strong argument that the district court was wrong here and that these plaintiffs don't have standing. They don't prescribe this medication. They don't take it. The argument is they will have to treat, some doctors may have to treat people who suffer adverse complications, but the burden of the plaintiffs here was to show that they would have to treat these people, and they really don't make that case at all. And it's hard to do it because the record makes clear that complications are extremely, extremely rare. They make some arguments about the general impacts on the medical system, but again, those aren't impacts on these plaintiffs. And I think a key issue that I'm sure my colleagues are going to return to is if these arguments work to establish standing, then any group of doctors who are opposed to a particular drug or vaccine can bring a similar lawsuit, and that will really open the door to very broad instability in the drug approval process. I'll just talk briefly about two other issues. One is the statute of limitations. The law says you have to challenge an administrative decision within 6 years. The approval of this drug was in 2000, obviously way longer than 6 years ago. The district court here said there was a reopening of that decision. I think all of the experts that have looked at the decision since Friday are very, very skeptical of that ruling. There's a very strong argument that the statute of limitations bars this challenge to the approval process. And again, think about the instability if every drug's approval can be reopened in this way. And finally, because the FDA is an expert agency, the statute says that people who want to challenge the FDA's decisions have to first bring those arguments to the FDA and have it decide them. And again, with respect to a number of the arguments here, there's a clear case that the FDA did not have a chance to consider them. So here, I think just on these process issues, before we even get to the substantive FDA decisions and the challenges to them, a very strong argument that the district court here was just wrong. So with that, I'll stop and I guess pass the baton to Bill.
Thanks, Andy, for the great summary. I want to give you a few minutes of background. As we all know, every prescription drug sold in the United States is approved by the Food and Drug Administration. This includes vaccines for COVID, vaccines for children, cancer drugs, AIDS drugs, drugs for heart disease, drugs for hair loss. Some have very strong safety records, such as COVID vaccines and Mifepristone. Some have very serious side effects and can even cause death, such as some cancer drugs. And some are very controversial. For years, there's been a political movement challenging children's vaccines. And there are challenges to COVID vaccines. But rarely has anyone even tried to go to court to overturn an FDA decision. And there's been one constant through all of this. Never has a court actually overturned an FDA scientific decision in approving a drug on the grounds that FDA got it wrong. Never until this decision. Congress, in the statute, directed the FDA to evaluate the safety and effectiveness of drugs, basically to determine whether the benefits of the drug outweigh the risk. This is a complex decision involving medicine, statistics, and sometimes epidemiology. Until now, there's always been strong deference by the courts to FDA's judgment. Allowing the courts to do this, to do this kind of searching inquiry and overturn FDA if the judge thinks FDA was wrong, in combination with the court's ruling on standing that Andy described, could allow anyone, virtually anyone, to challenge any FDA drug approval decision with a good chance of succeeding. And the reason I say a good chance of succeeding is because any FDA drug approval involves hundreds of judgments by the agency. And if a court feels free just to kind of take a fresh look at each of those, there's a chance that, a court will find FDA's one of those judgments wrong. So I want to emphasize 3 points. First is these are deeply scientific decisions. They involve medical judgment, statistics, clinical trial design, and epidemiology. These are not decisions that lawyers or judges are trained to make. Second, as I said, but I want to emphasize that there are hundreds of decisions involved in any drug approval. I counted 6 that Judge Kacsmaryk said were wrong, including should there be a follow-up exam after the drug is given? Should the psychological effects be considered? Should an ultrasound test be required before the drug can be prescribed? What is the professional training that a professional should be required to have before administering the drug? Again, these are not decisions that a judge is qualified to make. In addition, in this case, the judge looked at significant amounts of evidence that FDA had never seen, evidence from blog posts, certain kinds of surveys, and so on. The law has always been that the courts aren't allowed to do this. In reviewing agency decisions, they can only look at the evidence that was before the agency. And third, if the decision were upheld, it could have a devastating effect on drug and vaccine development in this country. It means that in order to get a drug approved, companies will not just have to survive sort of literally often hundreds of millions of dollars and years of testing, FDA scientific review, but then they'll have to survive challenges in court, which could be immediate or, as in this case, 20 years later. And this is why just really a few minutes ago, 250 drug companies announced that they had signed a letter urging reversal of this decision. So I will turn it over to Lynn Goldman.
And thank you for all of you for joining us this afternoon. I think this is an incredibly important issue when it comes to the health of the public, as well as our ability to practice medicine in a responsible way in this country. For doctors, our patients, and their families, it is critically important that we can trust the basis for the approval of a drug. That drug needs to be approved on the basis of the welfare of those who are being treated. And that needs to be based in turn on review of the science that's been developed around the drug. And as Bill Schultz very eloquently explained, there are reams of data that underlie every drug approval process, a multitude of decisions that must be made. And those decisions, for us to trust the consequences of that review, need to be made by scientific experts who understand those data and can best evaluate them. And those experts are not judges, and they're not courts of law. And the basis cannot be any basis other than the welfare of the patients and the science behind that, certainly not on the basis of beliefs and various other systems that might be brought into play. In terms of the drug companies, it is so important that they would not be put at risk by every single decision by FDA being subjected to some kind of judicial review like this. Many, many, many dollars are invested in the development of each and every drug that is in the market, and years of effort go into being able to not only discover new medications, but also to bring them to the FDA for review. And we have a need for new drugs. We have many diseases that are orphaned diseases for which we don't yet have treatment. We have chronic diseases like cancer and other chronic diseases for which our treatments are nowhere close to as good as they should be in terms of being able to cure diseases. And we have stages of life, entire stages of life like childhood and during pregnancy, where we're still doing fundamental drug development and testing to make sure that we can provide adequate medical therapy for people to save lives. And so at the end of the day, that's what this is about. This is about either saving lives, making people more comfortable, avoiding disability from having diseases that are painful or cause people to lose their productivity. It's also about, has always been mentioned, it's about having vaccines and the fact that, well, there might be people who disagree with some of the technologies that are used by vaccine makers, like the mRNA vaccines, but feeling uncomfortable about a technology is not the same thing as identifying that there is a risk. We have technologies that are extremely safe and have been proven safe, and that should not be called into question by the courts on other bases than safety. So I think that this is, for doctors, an incredibly serious moment, because up to now, we have been able to trust that an approval by the FDA is a science-based decision, and that we can say that if the FDA has approved a drug, that it is safe for us to use for the indications that they've identified. And it's important that we continue to have that. That is what provides us with the assurance, because most of us doctors on our own can't go through those thousands of pages of tests in order to make that judgment on our own. Thank you.
While folks queue up with their questions, let me ask my colleague to explain how we're going to do the questions, and I have one or two remarks while we're waiting.
Thanks, Leslie. So yeah, if you're a reporter on the line, you can let us know that you have a question by clicking the raise hand button at the bottom of your screen. You can also chat us a question or email it to us. I'm just going to give it a minute for some people to get the chance to raise their hands.
Maybe while we're doing that, I just want to conclude by thanking the speakers, but also by indicating all the layers of problems with this decision. The first is, as Andy mentioned, just the issues of standing and procedures, and how the judge was willing to twist those around. The second is the impact on law and practice that's been followed since the FDA was formed in 1938, and has done very well for patients and for drug development in this country, and what this will mean for the practice of medicine and what it will mean for patients. I mean, there should be no doubt, because we have seen the politics descend on these issues before, that when it comes to mRNA vaccines, when it comes to drugs developed with the use of fetal cells, even for testing, when it comes to gender affirming therapy, when it comes to drugs like PrEP, that there are people waiting in the wings to bring these drugs down. And if an individual judge with no training, with a clear ideology, is empowered to wreak that kind of havoc, there is no doubt that millions of patients will pay the price for that. Ashley, do you want to tee up the first question?
Sure. First, we're going to go to Susan. Okay, Susan, you should be allowed to speak. Now you just start out on mute.
Okay. Hi, can you hear me?
Yes.
Okay, terrific. I'm Susan Jaffe with the Lancet. I'm wondering if I could get in a nutshell, how should FDA approval be challenged? I mean, there are some drugs that have lost approval. How should that happen?
Should I take that?
Yeah, Bill, that would be great.
It can be challenged in court, but it could only be overturned if it's arbitrary and capricious, but there is a very strong deference to the scientific judgments of the FDA. And that's why I don't think any court has ever overturned an FDA decision. And that's why very few companies or others have even tried, because the courts give a lot of deference to FDA's scientific judgment.
So how does a drug like DES get taken off the market?
By FDA. So occasionally, FDA will decide that the drug is no longer safe or it's no longer effective, and it will take it off the market. And it has to go through a pretty complicated process to do that. Although usually if FDA decides to start that process, the company will take the drug off the market on its own.
I mean, I can add to that, Susan, that it is quite rare, but it has occurred on several occasions that people have identified data about adverse effects of a drug, and they brought that to the FDA. Typically, what the FDA has done is reassemble their science advisors to take a look at that. Their own experts analyze the data. And those things have resulted in changes of drug labels and even drugs coming off the market. And I mean, I personally have seen that process work, and it does work very well. FDA is quite willing to look at those issues. And
Thank you.
it's
Yeah.
not unexpected, Susan, given that no matter how many people are tested prior to a drug being approved, once the drug is on the market, potentially millions of people are treated, and there might be even rarer effects in those that can even be detected in the pre-market testing. That's a little different, though, than what's happening here. This is not really based on an adverse effect. This is a case that's being brought on other bases.
Thanks, Susan. Let's go to the next question.
Okay, next we're going to go to Karen Landman with Vox. You should be allowed to speak now.
Hi, thanks so much for taking my question and for having this informative call. I'm wondering if any of you have insight on where the idea that Mifepristone is unsafe comes from, and how that idea that it's unsafe has affected access to its use.
So I'll address that. I don't think there actually is an idea that it is unsafe. I think that there are people who are opposed to its use because they were opposed to terminating pregnancy, but the drug itself is actually very safe. That's not to say that pregnancy is necessarily 100% safe as well. So I think once somebody is pregnant, there are a number of things that can occur, including miscarriage, loss, unintended loss of the fetus. And there are risks attendant to that, just as there are risks attendant to terminating a pregnancy medically.
I think this is really the crux of the matter, that we've had a situation here where a drug's been on the market for many years and has shown to be safe and effective. Every drug on the market has side effects. All of us who watch television at night know that drugs have side effects. Any of us who have, or as family or friends treated for cancer, know that these drugs have side effects. But the FDA's job is to make a decision. But here in this case, we have a drug that's been well proven to be highly safe, with highly minimal side effects, taken off the market without any engagement of the experts in FDA, without the presentation of new data. Ashley, let's go to the next question.
Awesome. Thank you so much. So we have a couple questions in the Q&A. The first one is, can the FDA use its enforcement discretion to keep the medication on the market? And the second one is, how does the Washington decision impact the Texas decision?
On the first one, I don't know how enforcement discretion would keep a drug on the market. But, you know, at this point, the issue is really for the courts. The decision is stayed at the moment, which means nothing changes as far as the availability of the drug. And as Andy said, the government has asked the Fifth Circuit to extend the stay. And so I think that's the route to keeping the drug on the market while the courts are deciding the case.
I agree with that. I think, you know, the effect of the district court's decision, if it is allowed to take effect, is to essentially put FDA's approval on ice. And I think that, you know, opens the door to potential liability for manufacturers and other people. And it's not clear that enforcement discretion is a route to avoid, to give them the assurance they need. And I think Bill's right. You know, in our system, the way these things work is the district court makes a decision. It first decides whether or not to stay its decision. And if it decides not to, the party seeking a stay can go to the Court of Appeals and ultimately to the Supreme Court to seek a stay. And that's the process that DOJ has started. With respect to the Washington decision, and I think there's been a question about the extent to which and whether it conflicts with the decision issued by the District Court of Texas, and the Justice Department just also very recently filed a motion for a clarification with the district court in Washington, asking it exactly what the sort of scope of its order is and whether it conflicts with what the district court has ordered in Texas. So I guess we'll get an answer on that from the district court in Washington.
Great. I think we have time for probably, I know we have a hard stop, so we have about 5 minutes. So Ashley, why don't you take another question or two?
Okay, next we have Alyssa or Lisa. Sorry, I don't know how to pronounce your name, from NPR Phoenix. You should be all set to talk.
Hi, thanks so much for hosting this. And yeah, my name is Elisa. Thanks for getting that right. Appreciate it. I guess I have two very quick questions. First, from a legal standpoint, the judge in this case cites safety concerns and says the FDA succumbed to political pressure when approving this drug's use. Does it surprise you that this is the first time, as you say, that a judge has moved to invalidate an approval like this, and not in a case, like how does this compare to legal challenges around OxyContin? And then secondly, if there is time, if you could talk about the medical alternatives to this drug, and are there any other abortion pills going through the process of FDA approval that could potentially be streamlined? Thank you.
I'll just take the first half of it. I mean, I read the judge's opinion pretty carefully. There really isn't anything in that opinion showing political influence or that the decision was in any way political.
And we're talking about a drug here that has been in use and been monitored for a very, very long time without any scientific evidence of meaningful concern at all. Lynn, do you have something to add?
Yeah, I mean, on the second question, so, normally how we use medication for abortion is that there are two drugs that are used. First, Nifty, which is the drug that was involved in this decision, and I apologize. My dog is agreeing with me, actually. And then a second one, Mifepristone, which also is given. If the courts were to decide to let this decision stand, which I hope they wouldn't, it would be possible to just use Mifepristone alone for an abortion. And there are other medications that could potentially be brought on board. I should say there's another concern though, which is that with some of the laws that some of the states have been enacting, there are other medications that are not labeled for use for pregnancy, but are used for other indications, for cancer, for rheumatoid arthritis, other indications that have been swept in to some of the lawmaking that's been going on in the states. And it's possible, in addition to all the drugs that Bill Schultz and Leslie Dock mentioned that might be brought forward, some of these could also be brought forward because of the potential to use them to terminate a pregnancy as well.
I think that's time for the last question. I would just end a little bit by saying where Andy began, which is that the arguments for the stay are overwhelming. It is critical that the judge, the Fifth Circuit, and ultimately, if need be, the Supreme Court issue that stay, so that this ruling, this politically motivated, ill-founded ruling, can be reviewed by the courts, and overturned, as we believe it should be, without the devastating effects on millions of women around the country. That's the question in front of the courts in the very near future, and one that we think has an obvious answer. I just want to thank our panelists and everybody who's dialed in. Please feel free to reach out to Protect Our Care if you have additional questions for any of the panelists, and we will be sending a recording and the video of this out to everybody who has joined, so you can use that as well. Thank you, everybody.